Hey everyone, welcome. Let's talk about untying the knot in the Philippines. Now, you might think it's just a matter of signing a few papers and walking away, right? Well, actually, it is a high-stakes, incredibly rigorous journey through a very strict legal labyrinth. In this explainer, we're going to walk step by step through the precise legal requirements for annulment cases, exactly as laid out by the Supreme Court of the Philippines.
But right before we enter this labyrinth, we really need to define our starting line. You know, people toss the word annulment around as a catch-all term all the time, but the law actually distinguishes between two totally distinct legal concepts. First, you have absolute nullity, which is for void marriages, meaning these are marriages that literally never legally existed from the very beginning. Annulment, on the other hand, applies to voidable marriages. These are marriages that are perfectly valid right up until they're annulled by a court due to very specific grounds, like fraud, force, or a lack of parental consent.
Okay, let's dive into this. Here is the exact map we're going to use to navigate this dense procedural process. We'll be looking at filing the petition, the summons and investigating collusion, the mandatory pretrial stage, the trial and decision, and finally, properties and the final decree.
Just to give you a bird's-eye view, here is our chronological roadmap. As you'll see, it's a very linear, step-by-step journey, from day one of filing that initial paperwork, moving through the response period, the mandatory investigations, and all the way to trial. It's important to remember this is not an overnight process. It requires months of strict adherence to procedural milestones.
So let's begin at the starting gate with Phase 1, filing the annulment petition.
The very moment you submit your paperwork to the family court is absolutely crucial. Seriously, one wrong turn here can end your journey before it even really starts. Section 5 of the rules demands strict compliance right out of the gate. You have to allege the complete facts of your case and your property relations. You also have to sign the verification personally. You can't just have your lawyer do it for you. And finally, you have to attach a certification against form shopping. The rules explicitly warn that failing to comply with literally any of these steps means immediate dismissal of your petition.
Now, you might be wondering what actually counts as a valid ground for all this. Well, one of the most commonly invoked grounds is psychological incapacity, under Article 36 of the Family Code. Basically, this means a party was psychologically incapable of complying with essential marital obligations right at the exact time the marriage was celebrated. The rules say you have to allege the physical manifestations of this incapacity in your petition. But here is a really helpful detail to keep in mind. You actually don't need to include a formal expert opinion at this initial filing stage.
Moving right along to Phase 2, summons and investigating collusion.
So let's assume your petition is in perfect order. The court formally notifies the other spouse, the respondent, that the process is officially begun and they have a chance to answer. Which leads to a pretty fascinating scenario. What happens if they just ignore the summons? Like if they completely ghost the legal proceedings, do you just automatically win your annulment by default? The answer to that is a resounding no. Listen to this, straight from Section 8 of the rules. If the respondent fails to file an answer, the court shall not declare him or her in default. This is a massive twist compared to your standard civil cases. Because the state deeply protects the institution of marriage, the court is never going to just hand you an automatic win. Actually, instead of giving you a default win, the court gets suspicious. They immediately start thinking about collusion. This is a secret agreement between the spouses to basically deceive the court into granting an annulment. To prevent this from happening, the court orders a public prosecutor to actively investigate if the spouses are secretly working together to manufacture grounds for separation. So the public prosecutor effectively becomes the ultimate gatekeeper for your case. Within 1 month, they have to submit a report. If they find that collusion exists, boom, your petition is dismissed immediately. But if they report that no collusion exists, congratulations, you unlock the next phase of the labyrinth and keep moving forward. Which brings us to Phase 3, the mandatory pretrial stage. This is a heavily structured phase where the battle lines are officially drawn. Everything is laid out on the table before the actual trial even begins. The court requires a pre-trial brief from both parties, and it has to include your legal claims, admitted facts, the exact evidence you're going to present, and yes, this now includes those expert opinions we mentioned earlier, as well as the names of all your witnesses. You've really got to have all your ducks in a row here. But here is the absolute most critical rule of preparation at this stage. If the petitioner fails to appear personally, the case shall be dismissed. This stresses an incredibly important human element in Philippine family law. You literally cannot simply stay home and let your lawyer handle everything. Your personal appearance is an absolute mandatory necessity. And during this pretrial, the court sets some incredibly strict boundaries on what you can actually negotiate. There's a stark contrast here. On the one hand, you have prohibited compromises. You absolutely cannot make a deal regarding the civil status of persons, the validity of the marriage itself, or future inheritance. The state vigorously protects all of that. On the other hand, the court does allow you to negotiate practical, day-to-day matters, things like child custody, visitation rights, and how you're going to administer your property.
Next up is Phase 4, the trial and decision. Once pretrial wraps up and the pretrial order is issued, welcome to the courtroom. This trial is basically an unskippable gauntlet. The presiding judge has to personally conduct the reception of evidence. Your grounds for nullity or annulment absolutely must be proven with actual hard evidence. And because these cases deal with incredibly sensitive, deeply personal matters, the court actually has the power to order closed-door sessions. They can exclude the press and the public entirely just to protect your privacy and prevent any psychological harm.
So let's say after all the evidence is heard, the judge renders a decision and grants your petition. You're done, right? Well, not quite. The decision doesn't become final that exact day. You have to wait out a 15-day period from the notice to the parties. It only becomes etched in stone, assuming no motions for reconsideration or appeals are filed by the aggrieved party or the state during that time.
Finally, we reach Phase 5, properties and the final decree. Even with a final decision in hand, untangling your actual lives and assets is often the most complicated and financially significant stage of this whole labyrinth. In fact, there are exactly 3 massive requirements that must be met before the court will actually hand over the physical decree of absolute nullity or annulment. Let's break those down really quickly. First, you have to register the entry of judgment in the civil registries. Second, if you have shared assets, you've got to register the approved partition and distribution of your properties. And third, you must deliver the children's presumptive legitimes, which essentially means ensuring their inheritance is totally protected in cash, property, or sound securities. Properly splitting the property and protecting the kids, totally non-negotiable prerequisites. And once you've navigated all of that, the initial petitions, the prosecutor's investigations, the mandatory appearances, the trial, the property division, you finally receive this, the registered decree. According to Section 23 of the rules, this single document is the best evidence to prove your marriage has been dissolved. It is the ultimate prize of the entire legal journey, and the definitive, undeniable proof of your new civil status. Which really just leaves us with one final thought. Knowing the sheer procedural gauntlet we just walked through, the fact that you absolutely cannot default your way out, the mandatory personal appearances, the strict anti-collusion investigations, and the complex property liquidations, are you truly prepared for the immense legal and emotional journey required to legally untie the knot in the Philippines? It is a fascinating, incredibly rigorous system designed to protect the institution of marriage at every single turn. Thanks so much for joining me on this explainer, and keep learning.